Hi, I'm Alan Childress. I'm the law professor at Tulane, and that's Chaz there. Um, I've left the door open so the dogs could come in because they're pretty impatient that I closed the door on them. So I hope you don't mind the boomerang like, and Chaz are here as well. I want to talk about another book that's been around a while and is maybe not as bad as some of the other ones, but again, I would kind of warn you off of. And here comes Foxy. We have way too many dogs, but they're pretty innocuous. Uh, yeah. All right. So let me tell you about. First of all, I've always mentioned that you might want to consider getting a book that was written by an actual Louisiana notary, and that's my side piece book. Get it in the 2025 edition because that has the current key, and that's Dexter that comes in there. Key to the current pages in the state study guide, so it's not really useful. Some of the tips from an older edition are useful, but if cost is a problem, reminding you that we priced it at almost cost as an ebook, so you can get it on Apple Books app or Kindle or Barnes and Noble Nook. Now they're going to pretend fight in the background. Maybe shouldn't have let them all in. Sorry, guys. But I wanted to specifically say that this side piece is not this fake side piece that Amazon started selling a month ago. And they even pretty much took my subtitle. And one of the ways you know it's fake is they talk about that it has an index in it, a detailed index. And then you flip through it and there's no index whatsoever. So they loved my title, but then they wrote a book that's AI and generic, and I will review it at some point. But just be careful on Amazon not to get one that maybe looks better because some company designed it. Anyway, today's book, though, the one I want to review now, is written by Educational Testing Group. And it's fairly affordable, maybe only 18 or 19 bucks on Amazon. So it's tempting to buy it. I love the fact that they're honest, that this is written by a company. It is not written by a fake name like some of the others are. And it has been around a while. So I like all of that. I hope you don't mind dogs because there's no way of getting rid of them now without stopping. And I don't know how to pause in I use Zoom all the time. Our class at night is taught by Zoom. I'm familiar with working that, but I'm new to YouTube. One of the ways you can figure this book isn't the best book to study for the Louisiana exam is that it looks a lot like the one for Nebraska. And if you flip through the Nebraska one, you find many of the same questions. And that just can't be right with Louisiana's exam being so different. Oh, by the way, it's also just like the Tennessee one and a New York one and a North Carolina one and several others. So apparently what they do is, as a company, they go state by state with pretty much the same book, change the cover, and sell it to you. It's a scam, but it's a little less of a scam than the others in that many of the questions here do relate to, I will say, relate to Louisiana in the sense that to the extent there is consistency on some aspects of notary practice among states, there's overlap between Louisiana and some of these other states, then these answers are correct for that. Like how, that you have to identify somebody before you can do a signing, that you have to watch them sign, that you can't sign a notary act where you have a vested interest in it, a property interest or a personal interest in it. Those are common among states. But if you're going to say, then we're going to test on the things that are common among states or teach you about those, you're already eliminating 80%, 85% of the state study guide, which is about Louisiana law, and a lot of Louisiana law that notaries can practice that only lawyers would be able to practice in other states of their law, California law or whatever. Let me tell you some of the answers in here, though, that they got wrong. I said in my introduction, on my written introduction on the website, that this isn't so bad. It doesn't have so many wrong answers. It's just kind of beside the point because it focuses on such a narrow part. Maybe only 2 out of the 55 questions you get on the notary exam would be on topics that are in this book. That's a problem. But I thought that was I called it innocuous or harmless because of that. Then I looked through it again today with a little more detail, and I realized they actually have some wrong answers too, and not just beside the point or not tested answers. It also has plenty of not tested answers. One way you also know that it's kind of fake is the frequent mention of county clerks, the clerk of court of the county. Like on test number 2, question 3 says, who issues a summons? Well, first of all, there's no mention in the fundamentals book about issuing summonses, so it can't be tested. But they say the answer is county clerk. We don't have county clerks, as you know. And they don't know that, and they should know that. You would think that if they're writing this and trying to adapt it to Louisiana, that they would bother to know that we don't have county clerks. Well, they didn't bother. But let me tell you some of the answers that, again, I'm trying to use this to teach right answers and what's tested to help you study for the notary exam, and not just rag on the book. They go, like many of these books, they go a lot into keeping a journal. I don't even know if the word journal is mentioned anywhere in the state study guide, but it certainly isn't a required part of notary practice in Louisiana. And books that say that you must keep a journal, that might be true of other states, but it's not Louisiana, and that would not be the correct answer. This one doesn't quite say that. It just says that there's no requirement that notaries maintain a journal of their notarial acts. However, it is a very strong recommendation of the Office of the Secretary of State that you do so. I don't know where they got that from. It's not mentioned in fundamentals, and I don't see anywhere on the Secretary of State's website where they encourage that. Again, maybe they've sent out some kind of directive, or at some point they made a public pronouncement that journals are a good way to keep track of acts and customers. But there are other ways to do that, or you don't have to keep track of them as long as you're able to testify truthfully in court. If you ever get called to testify, you probably will never be. And some people keep a journal because they want to keep accurate records, or they want to do it for their own reasons, and that's fine, but it's not on the exam an answer. This question, which is also found in the Tennessee book I was looking at, if a person has been convicted of a felony, he may not be appointed as a notary public in which of the following? A, any state of the United States, the county of jurisdiction, right? C, any place in the world. Oh, wow. D, some states of the United States. They say the answer is any state. I don't know that that's true. But most of all, Louisiana is not going to test you on other states or what the other states do. They don't care. As you might know about Louisiana, we don't care what other states do. So they're not going to test you on that. It's nowhere mentioned in the fundamentals book what other states do about felonies, but they do mention that in Louisiana, those with a felony conviction may not become notaries. But even that answer is incomplete. A more complete and correct statement with those without a felony conviction who have not been pardoned are not eligible to become notaries in Louisiana. That is a qualification that you do in your application to qualify. You even verify that you either don't have a felony conviction or that you have since been pardoned for it. So this is just a wrong answer anyway, but definitely they're not going to test you on non-Louisiana rules. Which of the following about how to submit the application to qualify form and are correct? And then they talk about fees of $75 for the exam, mailing address, that you have to use a mailing address. This is very out of date. This book purports to be only like 5-6 years old, but it's been at least a decade that they've had a website that you use, and you don't really do it by a mailing address. Maybe you can do it by a mailing address. I wouldn't recommend it because you still need the website for all sorts of other reasons. So just go ahead and use it. Anyway, that's just such an out-of-date answer. Which of the following refers to the person, well, they mean refers to, but they left that word out, refers to the person who is a signer of and party to a document? They say the answer is principal. You know, in a lot of documents, party, appearer, signer, and principal are synonymous. The problem with that as an answer is that there are documents where the person signing it is not the principal, because that is really a term of art. and it would be wrong to say that the principal would be confusing. And for example, somebody who's signing on behalf of a power of attorney, on behalf of the principal for a power of attorney, is called a mandatory in Louisiana, and that person is not the principal. They're the opposite of the principal. So the signer would be the mandatory, or agent, or attorney in fact, or representative. Those terms are synonymous. The principal is the one who wrote the power of attorney and authorized them. So they could test you on that, but that would be a wrong answer for that particular setting. So using it generically to mean signer is inaccurate. But the reason I mention it to you is not just to correct the book, but to tell you that it's often tested on the Louisiana notary exam, the roles or names of people who are involved, like who is the one who takes out a mortgage? They're a mortgagor. Who's the one who gives the money in return for the mortgage? The mortgagee is the bank or the lender. That kind of names of roles is very common. So they absolutely could test you on, in a power of attorney situation, who they'll give you a fact pattern and then ask, John and Mary and Jim. And then they ask you, Jim is the principal, agent, trustee, settler, and you'd have to figure out which term fits with which role they play and match it to the name in the scenario, which becomes a reading comprehension kind of question. So I use it as an example of how they ask that kind of question a lot. Like in the above scenario, Jim was considered to be the A, some role name, B, some role name, and you pick the right answer. And those should be easy. I think the best advice I can give you on those is don't just go on memory. Try to quickly find it in the study guide by using an index that you put in there, or just flipping through it and finding it, because a lot of times your memory is just wrong about those. You get the terms mixed up because we use them, for example, the word principal very differently in the trust situation, where principal is the word for the property. Just like in a bank, you have principal and interest. Here, in a power of attorney, principal is a person, like the principal of a school is a person. And so you can get those mixed up if you don't quickly look it up. Other terms that are used in different ways, estate is used very differently with the predial servitude than it is in the context of successions. And mortgager and mortgagee, people mix up all the time. Lessor and lessee are easy to confuse. So instead of just going on memory, my tip to you is to have a list of those that you have handy and you've written into your study guide, and just quickly look at the list or use your index to find it in the study guide. Mortgagor is at the beginning of chapter 18. You go to that point and figure out, oh, the mortgagor is not the bank lending the money. The one giving the mortgage is the one who's actually borrowing the money. They give the mortgage, the promise to pay, in return for the money. So you can get mortgagor and mortgagee mixed up very easily. But it's often tested. That particular one is often tested. Another one that's often tested is the difference between an heir and a legatee in a succession. So look those terms up and be ready to answer them. They have a question here on when taking an oath, the signer should do what? And all the choices they give aren't correct. They say must raise the right hand, must pay an extra fee, must repeat the oath. I don't know where they're getting that about oaths. Which of the following happens if an appointee does not file his oath of office within the specified period? They say the appointment is revoked. I guess that's right, though the fundamentals book doesn't mention that. And that question is in the Tennessee book. So it's probably a correct answer some other state. But I don't know anything in chapter 7 that talks about revoking because you haven't filed your oath of office. They tell you do have to file your oath of office. They talk about certificates a lot in this book as some kind of special act. And we don't in chapter, in anywhere in the state study guide fundamentals, mention certificates as kind of a whole branch of, there's authentic acts and affidavits and certificates. That's not how it's broken down in chapter 19. Rather, they talk in terms of private acts, acknowledged acts, affidavits, and authentic acts. So this kind of emphasis on certificates is weird. And the next question, a jurat is added to which of the following? And they say certificate. Maybe it is in other states when they use certificates as some kind of special instrument, legal document. But I would have put B, affidavit, because a jurat is added to an affidavit. It's like one of the fundamental things about affidavits in Louisiana is that they have a jurat, often tested. See chapter 19 about affidavits and jurats. Also, the term jurat is defined in chapter 29 in a separate little heading called jurat. So once again, if you have an index to the book, you can easily find where it is and what its definition is. So I would have thought the correct answer is affidavit. And on the Louisiana notary exam, if they ask about, what is the conclusion of an affidavit called, it's jurat, J-U-R-A-T. Here's another one found in a Tennessee book, so it's not the same. Here's talking about certificates and how you can use them in any country except, and they chose Canada, and I circled Mexico just as a guess. It turns out Canada is the correct answer. United Kingdom or Guam are the other options. No mention in the fundamentals book about how you get certificates used in foreign countries. They do talk about apostilles, so you do need to learn the term apostille, A-P-O-S-T-I-L-L-E, which is again found in chapter 29, and I think also probably mentioned in chapter 7. Anyway, you definitely need to know about creating acts that are recognized by the embassies of other countries, and apostille is the way to do that. But it is not, definitely not given country by country the way this question is. They say, again, a question in the Tennessee book, which of the following appoints and commissions a notary public? They say the answer is Secretary of State. The actual answer should be governor, which they reject as an answer. It's B, governor, C, Secretary of State. And of course, you should pick governor. The governor appoints you. Now, in the commissioning process, the Secretary of State acts as an executive body for the governor. So I understand why you would think it is that. I mean, all you do, you relate to the Secretary of State. You deal with the Secretary of State. But the one who actually appoints you is from a list that the Secretary of State gives him or her is the governor. So get that one right. It's an easy point on the exam, frequently missed when I give it as a practice exam question, because people are going on their instinct, which is, I only deal with the Secretary of State, and the Secretary of State is going to be the one to tell me if I passed, and the Secretary of State is where I upload my commission documents. So yeah, I'm getting my commission from the Secretary of State. Not so. The governor appoints you, the Senate confirms you, and the judiciary has a part of the process as well, potentially at least. They say an affiant is a person who swears to an affidavit. That's correct. If they swear falsely, can they be prosecuted for? What can they be prosecuted for? And they say the answer is perjury. And I get that in real life you'd say, oh, you're committing perjury because you made a false statement on an affidavit. But Chapter 7 actually distinguishes between two crimes. In Louisiana, perjury is reserved for people who are testifying falsely, whereas those who do it in writing, in documents where they've sworn to the truth in writing, have committed false statement. And it's possible that by doing an affidavit, you are also testifying and then having it reduced to writing. And I could see that maybe you could be prosecuted for perjury. But the better answer, the one they would be looking for, would be false statement as a crime. And it's a serious crime. It's just that perjury is reserved for testimony. So that might be in a deposition or in court. And it would be a stretch to say it would happen because you orally made a statement reduced to writing in an affidavit. So they're not understanding that. Which of the following is the prime duty of a notary public? And then they give various things, all of which I think are duties of the notary public. So choosing the prime one is not correct. They talk about if you communicate by telephone and mail in a manner to cause annoyance, which crime are you committing? it is harassment, and I think you would get that right. I find no mention of that in the fundamentals book, so it's not on the state notary exam. They have a question about mobile notaries. There's, to my knowledge, no mention of mobile notaries in the fundamentals book. Maybe in the appendix where they talk about the Office of the Notary Public and the statute, Appendix A has, maybe there's a mention of mobile notaries, but you know, I think maybe they should teach and test on that, but they don't. They talk a lot about credible witnesses, the term credible witnesses. And I know that in real life, you might care that the witnesses are credible, but apparently that's a term of art in other states because they ask a lot about how you can identify someone. But they essentially say in this one, which of the following methods of identification cannot be used by Ryan? And they say Ryan's personal knowledge of Brian. You'd have to know the facts to get that. And by the way, using Ryan and Brian is very confusing. Hope that the state exam doesn't do that to you. But the truth is, and this is something to learn for the notary exam, Chapter 7 tells you that there are ways to identify someone reasonably and within the rules that don't require looking at their ID. And I'm not going to go into those rules now, except to say that you can do it by personal knowledge of the signer. And there's more to it than that, but that is an acceptable way in addition to or instead of using a passport or a driver's license. And therefore, it really would be a correct answer to say that Ryan's personal knowledge of Brian would be acceptable as a form of identification. Apparently not in other states. This one says, which of the following are the criteria to become a notary public in Louisiana? It's chapter 20 in their section 1. Being 18 years of age or older, being registered to vote in the parish of residence, read, write, and speak sufficiently of the English language, D, all of the above. They want all of the above, and I guess that's kind of the best answer of these answers. But this is tricky, and I think they could test you on this. You do not have to be registered to vote in the parish of residence if you're not a citizen. And so these are the criteria to become a notary public for citizens in Louisiana. You do have to be registered to vote, but a non-citizen, resident alien who's entitled to become a notary public doesn't have to register to vote, can't register to vote, and is not disqualified because they're not a voter. So what I teach you about the Louisiana notary exam is don't just assume your situation, you're probably a U.S. citizen, is the only situation. Don't answer the question by saying, well, I had to prove that I was a voter, therefore everyone has to prove they're a voter. Instead, look in the book and find the answer there rather than going by memory or instinct or remembering that you had to show that you were a voter. So I think that's a really bad answer. They think that the application to qualify must be notarized. It doesn't. As you know, the application to qualify can be done online. So again, maybe this was true at a time before the Secretary of State set up a website. They have a thing about whether you can use blue or black ink. There's no mention of that in the fundamentals book. They say blue or black ink is acceptable. And that's probably true in real life, but it can't be tested because they don't tell you what ink to use. The reality of what you should know, not for the exam, but for practice, is that blue or black is usually fine. There are loan re-signings that will have instructions that tell you specifically to use blue, or the next set will come and say specifically use black. So you have to do what they tell you to do, or they won't accept the loan documents. So, Countrywide will have a different rule from Rocket Mortgage. And the good news is that when you get to become a commissioned notary, those refis and loan closings come with a detailed set of instructions for the notary. So they seem like they'd be intimidating or an area you wouldn't want to practice in because you're not comfortable with real estate. But they actually turn out to be one of the easiest things to do and still charge money, a decent amount of money for. And that's because it comes with a checklist. And if you print out the documents and the checklist and follow the checklist, you'll be fine. One of the checklists will probably tell you what color ink to use. And I'm going to be wrapping up soon. I just wanted to illustrate a few things from this book. Here's a whole section on credible witness, whatever that term means. Here's a mention of county clerk and bank guards. There's no mention of bank guards as an official officer anywhere in the study guide. There's several questions having to do with a notary seal is the impression of the notary public ink stamp or crimping embossed, they meant embosser, and is used to authenticate the notary's signature. No, your signature is your seal for purposes of the exam answer. And they got that one wrong like 3 or 4 times in this book. And in fact, you'll find a lot of the questions just repeated, or at least if phrased differently, are looking for the same answer. And again, probably because they're drawing from maybe only chapter 7 and a few outside of that, but no mention of testaments, drafting testaments, successions, power of attorney, other than that term principal that I say they're using, kind of missing the point that agents can also sign documents. That should be what are the ones signing the document. No mention of adult adoptions, emancipations, of matrimonial agreements, of family law, paternity, of contracts, leases, mortgages, conveyances of land, credit sales, vente arrendar. All of these terms in chapter 21, heavily tested, not mentioned in this book. So I don't recommend this book, even though it is, to its credit, affordable and doesn't pretend to be written by somebody who doesn't exist. So I like that aspect of it. It's kind of an above board con as opposed to a tricky con like some of the others. But it's still a con because this will get you either wrong answers or beside the point irrelevant answers for the notary exam. Using this to study would be a very bad idea. Okay, well, that's what I wanted to do today. I hope this was useful to you. Think about taking our class, which is on Zoom and recorded and available statewide. We have a class coming up May 27th, 2025. Our summer session starts for a fall exam. But if you're taking the May 17th exam and you still haven't taken a class yet, or you're not clear on the classes you have been taking, we do have our spring class available on video. And you could catch up and do the last few classes live if you wanted, but I wouldn't try to do that. I would just use it as an on-demand class. We treat our on-demand students the same we treat a live student, and a lot of our students are on demand. So we give them feedback, and we give them 4 practice exams and answers to those and explanations of those. We answer all your questions almost immediately. I think everybody would say we are the most responsive teachers because we live for this. We're here for you, and we want to help. So think about taking our classes. We're at schoolofnotary.com, or you could also find it at childressnotary.com. And we're here for you. Thanks, guys.